Okay, so I think the numbers have steadied now in terms of volumes of people joining. Welcome to the 45 of you that are on the link. My name's Claire Millns. I'm a barrister at Park Lane Plowden Chambers, and I have been for over 20 years now. I also sit as a fee-paid employment judge in the Midlands East region for about 30 or so days a year. With me, I've got Robert Allen, and Robert is a pupil at the Newcastle end of Chambers this year. And at the moment, he's in his second six, which means he's on his feet, and has recently appeared in the Employment Tribunal and has other bookings for tribunal work too, as well as commercial work and some personal injury. So we're going to move now on. I think Robert's going to move the slides on to the introduction and get on with the talk. So what we're going to be considering today is the talk in three broad sections. What it means to be neurodivergent is something Robert's going to talk about, explaining what it means, what it forms and why it's important. I'm going to then look at the legal considerations around neurodiversity and some of the cases involving neurodiversity in the workplace. There aren't many, but we're going to look at some more recent ones. And then Robert's going to finish with best neurodiversity practice for employers. In terms of questions, we are going to suggest at the end that any of those are emailed to us, because this forum is not always brilliant for asking questions, and we trust that you will get in touch with any queries that you've got. We'll also be sending the slides to everybody, and this webinar is also being recorded and will be posted up on our website in the next few days. So the first question is really, why did we choose to talk about neurodiversity in the workplace? Well, in my view, it's become a much bigger topic for a lot of my clients, and probably in the last 6 to 12 months, I've been fielding queries and questions about neurodiversity and the management of employees with neurodiversity issues. And I recently did a talk to some of you who are attending today about Section 15 of the Equality Act, and in each of those talks, I did several in-house talks. Issues about neurodiversity and Section 15 came up in discussion as well. So we thought it was something that you might want to hear about, something that you're advising your clients about, advising claimants about, if you're claimant lawyers, and advising respondent businesses about, if you're respondent lawyers. There's undoubtedly an increased awareness about neurodiverse condition in adults, and a University of Exeter study in 2021 found that the number of autism diagnoses had increased a staggering 787% in the past 2 decades. And figures released by the NHS Business Services Authority suggest demand is soaring for medical treatments for the neurodiverse condition of ADHD, with an estimated 170,000 identified patients being prescribed at least one drug for ADHD between July and September 2022, which was a 20% increase on the same period in 2021. There's also, you may have noticed, a real celebration of neurodiversity in the media. Many celebrities are speaking about their diagnoses, and the likes of ADHD as an adult diagnosis is becoming something talked about in lots of forums. We've got Emma Watson, the actress, Jamie Oliver, Anne McPartland and Bill Gates, to name a few of those individuals who will speak publicly and, importantly, very positively about their diagnoses. In February this year, on BBC Two, I watched Chris Packham, who fronted a 2-part documentary series called Inside Our Autistic Minds. If you haven't seen it, it's a really interesting watch. Chris meets other autistic people. He is autistic, and helps them create short films to reveal to their family and friends what's really going on inside their minds. That is an excellent programme for understanding more about autism, which I'm sure a lot of us will learn a lot from doing. Now, this increased awareness undoubtedly is going to lead to an increasing number of claimants in the Employment Tribunal bringing complaints which relate to their neurodiversity. And it's one then that it's already happening, it's increasing, and we need to be prepared for. So moving on then, I'm going to move on to Robert now to talk about what it means to be neurodivergent. Thanks, Robert.
Thank you, Claire. So before we get to trying to establish a definition, or perhaps a better way of putting it would be looking at several definitions of neurodiversity, we thought it would be appropriate just to set the scene of all of this and put it into context from an employment perspective. As Claire's just touched upon, awareness of neurodiversity has increased quite staggeringly in the last 5 years particularly. We've seen a huge increase, and we'll see that in some of the case law that we look at as we move forward into that section. But in terms of employment-specific awareness, we've put up a statistic there from a recent study by O2, who found that actually the majority of employers at the moment admit to having little or no understanding of cognitive differences that people may have. And of course, that in the abstract, what does it mean? Of course, it means that when they're looking at their workforce, not only do they not understand by majority the differences that there are, but it follows don't understand the differences and the impact that that will have on the type of work that employees do in the workplace. So that's a pretty interesting statistic to see where things stand at the moment. And hopefully we can assist in aiding with that awareness today. And of course, as Claire's touched upon, why is this important? Well, because it's estimated that around 1 in 7 of us are thought to be in some way neurodiverse. That's according to the ACAS guidance on neurodiversity. And we'll look at some of those particular conditions. But before we do that, defining neurodiversity, we've put 2 definitions up there because it is quite difficult to define exactly what the term encompasses, but the Brain Charity has quite a short definition. The concept that our brain differences are natural variations, and that really encompasses all of the various characteristics and all of the various traits that each neurodiverse condition can be identified by. Some of the conditions that we're going to be looking at today are very varied in terms of the traits and characteristics that they can result in. But it's really about looking at our differences and starting to be able to identify the trends in those differences, and then applying them in an employment context where adjustments need to be made. And then a slightly different, but really the same theme, the definition from the ACAS guidance, that again, we're looking at the natural variations. And the crucial thing there is at the bottom, we have different interests and motivations, and naturally better at some things and poorer in others. Of course, in a workplace context, that's going to be really crucial because it's having an awareness that some people perhaps are able to adapt to certain situations, whereas others would struggle in the same context. So those are 2 definitions which set the general theme of neurodiversity. But perhaps an even more appropriate way of looking at it would be to look at some of the specific conditions in question. So if we move on to some examples, we've put them there. There's 6 examples that we've chosen. We could have chosen many more, but we are limited for time today. The top 3 are perhaps the 3 most prevalent, or certainly 3 of the most prevalent that are identified and diagnosed at the moment: autism, dyslexia, and ADHD. But it's also worth being aware from an employer's standpoint that there are various other conditions which are identified as falling under the umbrella of neurodiversity. We've likely heard of Tourette's, but being aware not only of the verbal tics that Tourette's can lead to, but also the physical tics as well. Dyspraxia there in the middle, bottom middle, to do with difficulties in physical coordination. And dyscalculia, challenges around the use of numbers and mathematics. So seeing some of those slightly less prevalent conditions, perhaps there's slightly less awareness around those at the bottom and the traits that they can lead to, is going to help in being able to understand exactly what neurodiversity can result in this context. So because we're limited on time today, we're going to focus a little bit more on those top 3 conditions, again, because of their prevalence. So if we start with autism, and we've got the National Autistic Society's definition of autism there. I won't read it out, but it's essentially looking at the way that we communicate with one another and challenges in interpreting that communication. Of course, from a workplace context, that is perhaps going to be the most fundamental thing when we're working in a team environment. understanding communication and the variations in communication skills people have, and the way that communication is interpreted from one person to the next is of paramount importance in any working environment. And there is relative prevalence of autism. 1 in every 100 people at the moment are said to have autism. And it's worth pointing out as well there that it can be a hidden condition. That's something which Claire will touch on again in the case law that we look at. And of course, it's also worth pointing out that there are various forms. As with many of these conditions, there are various forms of condition, and Asperger's syndrome is one form of autism, but of course, it's not the only form. If we then look at dyslexia briefly, which is the difficulty with fluency in word reading and spelling, again, that can have a quite considerable effect in the workplace. It's not difficult to imagine the ways that that can pose a challenge, not just in writing documents, but of course in interpreting things like emails and in all of the written words that we use at work. But it can also have other characteristics. We've seen there verbal memory and verbal processing speed being some. So it's not just confined to spelling as it perhaps is sometimes perceived to be. And it's also worth pointing out, as the British Dyslexia Association has, that it occurs across a range of abilities, and it's not defined in one distinct category. There are no clear cutoff points, as I said. It's a broad range. It is a spectrum of dyslexia and can affect people in very different ways. In terms of prevalence of dyslexia, it's estimated that 1 in 10 people in the UK has some degree of dyslexia. So again, it's a very prevalent form of neurodiversity. And then finally, briefly on ADHD, which is attention deficit hyperactivity disorder, that leads more to people's behaviour. So it can perhaps have traits shown of focus and restlessness, ability to concentrate for long periods of time, and the habit to act impulsively. But it can also, and this is a really important point, not just about ADHD, but neurodiverse conditions generally, it can lead to consequences which may not realise themselves at work, but do in other aspects of life. So there, for example, as NHS England have identified, people with ADHD can have issues sleeping, or they can have anxiety in other areas of their life. And whilst an employer at first glance wouldn't be able to see those aspects, the effect that that can have on a work pattern is obviously going to be considerable. So it's worth identifying that neurodiversity at work doesn't just mean neurodiverse traits when the person is working, but can be in other aspects of the life that have consequences in work too. And just on prevalence of ADHD, it's estimated at the moment to be in the UK population around 3 to 4% of adults. And interestingly, according to the National Institute of Health and Care Excellence, I should say, the male to female ratio is said to be 3 to 1. So that's just an interesting bit of data about ratios and prevalence of ADHD. And finally, before we get into the legal aspects of this, a point on labelling and terms. It's difficult navigating some of the terminology in this area. What we suggest in that area as a starting point is to look to the way that judges apply the terminology, because of course, in a tribunal claim, the judge is going to be applying the standards which would be expected across society. It's helpful to see the standards that are identified by the judiciary. And a point that we're going to come back to today is the Equal Treatment Bench Book. It's essentially the guidebook for judges in how they address various aspects of the sensitive aspects of a claim in dealing with people who may come in front of them. And of course, neurodiversity is an issue that the Equal Treatment Bench Book deals with. From page 141, it talks about terminology around neurodiversity. And we've set out there some guidance from the bench book about things to avoid. So importantly, we're not to make comparisons with normal. There is arguably no normal, and thank goodness there isn't. The world would be a very dry place if it was. But avoiding comparisons with normal and neurodiversity is pretty fundamental. But it goes further than that, avoiding negatives. So rather than saying somebody suffers from dyslexia, perhaps they experience dyslexia. And that accommodates for the fact that it's not just posing challenges, but actually these conditions are offering many benefits and many opportunities too. And then labeling, again, rather than saying dyslexic, it might be more appropriate to say a person with dyslexia. And finally, cultural differences. So some cultures may use different words than our own, and emotional rather than mental. So emotional well-being and emotional health rather than mental well-being and mental health is something to pick up on. Perhaps some of the time we're saying the same thing, but we might be using different words to express that. So looking at some of the terms and labeling is perhaps a helpful place for us to start as we go into the legal aspects. And with that in mind, I will now hand over to Claire, who's going to be addressing the legal framework in this area.
Thanks, Robert. Well, we did have a question in the chat box, which I've hopefully answered best I can, but hopefully it may be answered by discussion about Section 6. Because, of course, to gain protection under the Equality Act, a neurodiverse employee needs to meet the definition of disability within Section 6. So it should go without saying that not all of those with neurodiverse conditions will, of course, meet that statutory definition. That can create, of course, particular difficulties in these types of claims because disability can be so-called hidden or invisible, as Robert says. Now, as we know, I've put the statutory effectively definition up on the screen for you. An individual's disabled if they effectively tick certain boxes. First is that there's a physical or mental impairment. Secondly, that has a substantial and thirdly, long-term adverse effect on their ability, fourthly, to carry out normal day-to-day activities. Now, the focus is likely to fall, I think, not as the question asked in the chat on whether or not this is an impairment. I think the focus in these types of cases, as with mental health conditions, which frequently come into the tribunals under the tribunal's gaze to determine whether somebody is disabled or not, the focus is going to be on the ability of the neurodiverse employee to carry out normal day-to-day activities. Is there an adverse effect caused by the condition or impairment? That was a point made in relation to mental health from the case of Jay against DLA Piper, which you may remember. However, what employers cannot do, of course, as we can't do with mental health conditions either, is make assumptions. So one employee who comes before you who has ADHD, for example, may well fulfill the statutory definition, but another may not. A one-size-fits-all approach is not helpful. And the other thing which I did want to raise is deduced effect, because the deduced effect provisions fall within buried away in Schedule 1, paragraph 5.1 of the Equality Act. And what the deduced effect provision says is this: an impairment will be treated as having a substantial adverse effect on a person's ability to carry out normal day-to-day activities if, 1, measures are being taken to treat it or correct it, and 2, but for the measures, the impairment would be likely to have that effect. Now, in my view, this is far more likely to be relevant in terms of neurodiversity in respect of ADHD. You remember what I said at the beginning about medication for ADHD. In terms of my understanding and research, albeit that's with the caveat I'm not an expert in neurodiversity, that medication is far less likely of those with autism. There are some medications that can be used, but far less likely, much more likely in the arena of ADHD. Now, the case of Woodward's mentioned at the bottom. It's a fairly old case, you may well know, but the Court of Appeal held that a tribunal should assess how an impairment would affect the claimant's day-to-day activities if the medical treatment were stopped. Okay, we then move on to the next slide. I've just put up there the case of Elliott and Dorset County Council, which is an EAT decision from 2021 and a decision of His Honour Judge Taylor. And it's a decision made at a preliminary hearing on disability, which went against a claimant, Mr. Elliott. Now, Mr. Elliott was an IT systems manager who was disciplined for false time recording. He said he found it difficult to accept the new time management rules, and he also found communication with his manager difficult. Now, during the disciplinary proceedings in relation to those matters, Mr. Elliott's union representative suggested that he be referred for assessment to consider autism. And that assessment indeed revealed that Mr. Elliott met the criteria for autistic spectrum disorder, as well as, including Asperger's syndrome. Now, the respondent did not dispute that assessment. It had happened during its disciplinary process and came to the tribunal accepting that, of course, Mr. Elliott had autism spectrum disorder and Asperger's syndrome. But nevertheless, there was a fight on whether or not he fulfilled the statutory definition of being disabled under Section 6. Now, the tribunal found he was not disabled because of his impairment, because his impairment did not have a substantial adverse effect on his ability to carry out day-to-day activities. It was the substantial part of the statutory test that was not met. Now, we need to remind ourselves here that Section 212 of the Equality Act deals with the definition of substantial, and that means more than trivial or minor. So not necessarily according with the ordinary understanding, we need to go to the statutory definition. So more than trivial or minor. Now, the EAT criticised the representatives at the employment tribunal stage and said, well, I don't think anybody actually took the employment judge to that definition. But nevertheless, the judge did refer to that wording. But the finding that the judge made was despite the fact that the claimant had actually only been diagnosed with autism and Asperger's because of the problems he was having at work with timekeeping, which makes the fight about the issue all the more remarkable. And also the claimant's own assessment of his personality traits, which the judge accepted entirely, were as follows: that he had difficulty processing other people's emotions, that he struggled to assimilate verbal and non-verbal communication directly, that he found it difficult to cope with a change of plans, that he had black and white thinking, that he took people very literally at their word, and that procedural compliance and a strong dislike by him for any regression from the rules. So in remitting to a fresh tribunal, and in overturning the employment tribunal, in remitting rather, and finding a successful appeal, His Honour Judge Taylor found that the tribunal had placed too much focus on what Mr. Elliott could do rather than what he could not do. It had also fallen into error by making a comparison between Mr. Elliott and general members of the population rather than with himself, absent the disability. And that, if anything, is the main issue I'd like you all to take away from this case, because, and that's what I've set out at the bottom, the tribunal has to consider whether the claimant is affected to more than a minor or trivial extent in carrying out day-to-day activities, which include work activities, as a result of the impairment in comparison to what the situation would be if the claimant did not have the impairment. And that, of course, is a difficult question, but that's the question one has to address, not with any comparison with the population at large. And that's the danger, the trap that the judge is said to have fallen into here. Now, His Honour Judge Taylor, you may be interested to know, commented that the parties may wish to consider whether actually they would like a preliminary hearing on disability. A big hint to the respondent if ever there was one. And indeed, if you were for the claimant, it may be that you would consider applying for a deposit order if the respondent continued to pursue a dispute in relation to disability. That case is a great one if you want to have a look at what is meant by substantial adverse effect. It's a really good run through the authorities, and it's also a warning really against placing too much reliance on the Equality Act Code of Practice and the guidance in the Equality Act on matters to be taken into account in determining questions relating to the definition of disability. Ultimately, His Honour Judge Taylor said the words of the statute rule supreme, and that is the starting point, not the guidance. And the guidance really should only be used on those cases that are borderline, that are really very difficult. Moving on then to defining disability. I've just flagged up a case of JC and Gordonston schools. It's an education discrimination complaint. It's not a tribunal one, but it's interesting and food for thought on this issue of ADHD, because child was found not to have ADHD, not to be disabled with ADHD. Day-to-day activities were carried out. It was found in an entirely normal fashion. ADHD had impacted on her social skills, but the effect was not substantial. So it's no more than minor or trivial. It didn't meet that more than minor or trivial. Now, in my view, those who are presenting themselves to the tribunal with ADHD, there's far greater scope for battles over whether someone is disabled than, for example, with autism. And in that way, in my experience, it's similar to cases with dyslexia. Over the past probably 3 or 4 years, I have done several preliminary hearings where disability is an issue and the impairment is that of dyslexia. And that doesn't always go the way of the claimant at all. I think it's 50-50 in my experience in terms of the particular facts, of course, fact sensitive of those cases. But it's important, and you may well find yourself in the arena of having to instruct an expert, and that's indeed been my experience recently. And of course, you're into then the Decayser principles on instructing an expert, and you're looking at consultant clinical psychologists. I've had one case involving a psychiatrist. Indeed, Dr. Colville, who is somebody who members of Chambers interviewed for a podcast recently, a consultant psychiatrist, has provided reports in respect of autism, I understand. A colleague. So that's when we're going, that is going to be, in my view, the greatest battleground. So moving on then to Fotherington, this hidden disability point is really important because it may be that you have a client, a client who's a claimant or a client respondent, and it's not until they get entrenched in a disciplinary process that disability reveals itself, or the potential for disability reveals itself. And because the individual involved does not know themselves or has never challenged themselves to think about, or a member of the family hasn't raised it, that they may in fact have a neurodiverse condition that affects their ability to participate in the world of work. Fotherington and Perth and Kinross Council is an example of that. Mr. Fotherington wasn't aware he had Asperger's syndrome, which caused issues at work. And he was a secondary school teacher who took several periods of sickness absence with stress and depression, and he had various problems with staff, parents, management at the school where he worked, and most of those related to him taking a really rigid and inflexible stance towards the following of the rules and procedures in the school. Now, following a suggestion from his GP and his partner, a referral was made to a psychologist, and he was diagnosed as suffering from Asperger's syndrome, which is a form of autism. After researching the condition himself, Mr. Fotherington realised that how actually the problems at work were likely to be attributed to his Asperger's. And the respondent obtained an occupational health report during the disciplinary process, proposing various reasonable adjustments in light of his Asperger's syndrome. He returned to work after a period of sickness to a non-teaching role and eventually lost his job. He was dismissed. Tribunal found that the council had failed to make reasonable adjustments. Further, there was found a successful claim, and usually of direct discrimination, because of stereotypical assumptions about his ability to teach following his diagnosis, and the failure to follow a redeployment process. He won his unfair dismissal claim and direct claim. He also, further findings of section 15 and indirect were also made. So that case covers many of the claims that one can bring or one can face in respect of those with neurodiverse conditions. And that takes us on to the next slide. The legal considerations, I've labelled them the big four. Of course, it doesn't mean that there aren't claims of direct discrimination and victimisation, which are obviously missing from that slide. And the claim, of course, which is part of a direct claim of stereotypical assumptions that can arise on the facts. But these are the main areas, in my personal opinion, that we come across when dealing with claims of this nature. So if we move on, I'm going to just focus really on section 15 and section 2021 in the time that we've got, because I want to move on, of course, to the case law as well. So section 15, I'm assuming you are all very familiar with this. What we know about section 15, of course, is it's something which generally greatly benefits claimants in the tribunal, and because disability does not need to be the sole or main reason for the something that arises, the disability needs only to have had a significant or more than trivial influence on the something. So if the something is difficulty understanding instructions, or difficulty complying with time management systems, or difficulty communicating with those who are working around you, as long as that has been significantly, there is a more than trivial influence by the neurodiverse condition, which also satisfies section 6, then it is a something arising. Okay. Knowledge of disability is required, but we'll all remember from, and if we don't know, please read Grosset and York City Council for an eye-opening read on the next part, which is knowledge of the something arising is not required. So you as the employer can have no knowledge of the thing that arises as a result of someone's condition, someone's disability, and that doesn't matter, and you can dismiss them for that, and that doesn't matter. You'll still be found culpable under section 15 of the Accord Act, unless, of course, you can succeed in a defence of objective justification. And in terms of objective justification, if you're looking at situations where employees go through the capability or disciplinary procedure as a result of something that arises out of their disability, in cases you're looking at, the legitimate aim is generally something along the lines of maintaining appropriate standards of conduct in the workplace and safeguarding employees. That's generally what it'll be. Now, moving on to section 2021. Of course, that's the duty on employers to make reasonable adjustments to premises or working practices to help employees and job applicants. So, of course, I've dealt with a few cases recently to do with job applications, adjustments to the application process, such as not being able to comply with the usual interview process, requirements for adjustments to that interview process, requirements to adjustments to filling in online forms, applying for jobs. So all that area is extremely important. And of course, the knowledge requirement is different in section 20 to 21 as it is to section 15. There's no duty to make adjustments unless the employer knows, and that's actually or constructively, both that the employees in question is disabled and is likely to be placed at a substantial disadvantage. Now, the relationship with section 15 is important. In essence, if you're found to have failed to make a reasonable adjustment, then don't expect your objective justification defence to succeed, is a lesson learned. So moving on then to the case law, I'd take you to Sherborne and Empire for those that are advising businesses, as really how not to do it, how not to treat somebody with a neurodiverse condition. And also it's a salutary lesson on education of those employees. And obviously the statistics we got from Robert at the beginning show that really there still is a real lack of understanding in this area, which is a real shame and needs to be addressed. So this was a first instance decision, and the employee was required to work in an open plan setting with a busy walkway behind him. He had autism, and this caused him to feel overwhelmed and distracted. He later became distressed with changes in the working environment and had a breakdown, sadly, at work. And his employment was terminated. He's a fairly young individual, only in his 20s. And his employment was terminated about 12 months after he started, after a whole series of unfortunate events relating to his disability and his conduct. And he brought claims of section 19 and section 21, which were both successful at the Employment Tribunal. The PCPs in the section 19 claim were failing to implement adjustments, the use of the capability procedure and effectively the use of the dismissal as a tool to rid themselves of the employee. And the tribunal really criticised Empower, and we all know Empower, it's a very large organisation. They criticised them to implement an appropriate neurodiversity policy. And they said that lack of policy contributed to the lack of empathy shown towards the claimant. And it was found that there'd been continuous management failure to understand the disability, failure to implement reasonable adjustments, including those recommended by the occupational health. And the line manager was found to have made little attempts to actually understand, despite obtaining, in this case, occupational health. And instead, I think it was about 3 weeks after occupational health started disciplinary proceedings. So it's a sad case on how Mr. Sherborne was treated, but it's a lesson to, I hope, for those advising employers on really what not to do and to take action in respect of educating employees, particularly those in managerial positions. Next case is Morgan and Buckinghamshire Council, which was a recent case, 2022, and it was one that was considered by His Honour Judge Auerbach in the EAT, and he upheld the decision of the Employment Tribunal. Now, Miss Morgan was a social worker for the respondent's fostering team, and as she was dismissed for giving, for conduct reasons, she was giving gifts to children for whom she was responsible without authority from her manager. And there was also an issue about what she'd recorded in the child's case notes about the occasion of her giving the gifts. So the respondent accepted entirely that she was disabled by reference to autism spectrum disorder, dyslexia, and other matters. Her claims were of ordinary unfair dismissal and also Section 15. So she's saying that her dismissal was there something arising. And she said, effectively, she was saying, look, I believe that the conditions that I had caused the conduct. So my autism and dyslexia, more autism, I think it was in this case, caused me to give the gifts to the children and behave in the way that I did. Now, the objective justification defence was successful. The tribunal found, as well as her not being unfairly dismissed, it's found that the decision was in the band of the reasonable responses open to a reasonable employer. But the Section 15 claim in particular is of interest. Objective justification was, they said the respondent reasonably formed the view that she breached professional boundaries and it could not be confident that she would not do that again. So this wasn't the case of somebody who they could speak to and explain or could make adjustments to the working practices. Now, the claimant's case, as I said, internally and before the tribunal was that her conduct was influenced by autism. Now, the dismissing officer didn't accept that at all, blanket refusal. At appeal, the appeal officer internally, that is, invited her, Mrs. Morgan, to agree to an occupational health referral, and she declined that. And you can't but help feel that she rather shot herself in the foot in respect of refusing that occupational health referral, because that may well have provided greater evidence to support her claim at appeal, and indeed created a greater sympathy, I think, at the stage of the original employment tribunal. She did have one successful claim, and this is also an important learning point in my view. And the successful claim was for disability-related harassment. And the disciplinary appeal letter outcome she received said this: it is also of great concern that you chose to withhold your autism through masking, and it put the word masking in quotation marks. So it's masking throughout much of your employment, potentially putting at risk the vulnerable children with which you were working. Now, this highlights, of course, the importance of taking care to use non-discriminatory language in any appeal outcome letter. But really, from my point of view, it is educating people about what masking is. That documentary I referred to at the beginning, that's great. That really helped my understanding about masking. And it seems to me it's something that everybody needs to be, who's in the employer situation, be educated about to avoid the situation that we had in Buckinghamshire Council. Now, Miss Morgan, reasonably, it was found, took the suggestion to mean that she'd been deceitful. And she said, well, no, I was adopting learned behaviours which had the result of masking my autism. That was part of my condition. So that was her successful harassment claim, one that we can hopefully learn from. So moving on then to the last of my cases, it's McQueen and the General Optical Council 2023. For those of you that get your Daniel Barnett alerts, you may have seen this in it. It is the decision of the Honourable Mr. Justice Kerr in the EAT. And it is appealing the decision of an employment judge called Sarah Goodman. And now Sarah Goodman, you may have heard of, because in June last year, she was in fact the judge that heard the Ellison Bailey and Garden Court and Stonewall litigation, which was of interest, very topical litigation, and was of interest to many. Now, Mr. McQueen was employed as a registration officer by the General Optical Council. He was disabled because of symptoms of Asperger's syndrome, dyslexia, and the way the judge phrased it was neurodiversity and left-sided hearing loss. There was just that blanket term used to describe him, his conditions. Now, the claimant had been examined at various times during his employment by occupational health, a psychologist, and a psychiatrist. The medical evidence indicated that when he was stressed, Mr. McQueen, or in conflict, that he would raise his voice and adapt mannerisms suggestive of aggression with inappropriate speech and tone. Now, he became involved in some difficult interactions with his co-workers, and occupational health recommended that in its assessment, they recommended some adjustments. One was that if you're going to tell him how to do a task, that should be done through email, not face-to-face. And that he should also be given what's called a recording pen, so he can record conversations, so he can get them afterwards to understand instructions too. That's fine. The tribunal found over the course of his employment with the respondent that he had several meltdowns. Now, meltdowns were a term used by the claimant and then adopted by the judge. And in these meltdowns, he would display loud and angry or otherwise, it's called otherwise unacceptable behaviour in the workplace. Now, 2 of these meltdowns and other matters, including misleading applicants over policy, there was some issue about him advising on policy. They led to Mr. McQueen losing his job, being dismissed for misconduct. Now, he brought various claims, a Section 15, and that was in relation to, among other things, treatment following his meltdowns. And it was the claimant's case, quite understandably, that the meltdown behaviour was something arising in consequence of his disability, arose because of his disability. Now, his claims in the tribunal were unsuccessful, and the tribunal found that the claimant's disability or any symptoms thereof was not the cause of the termination, and that the behaviour displayed by the claimant on the relevant occasions did not arise in consequence of disability. And that's important. And the Honourable Justice Mr. Kerr rejected any argument that actually the judge had got that wrong, and effectively said, well, look, once the tribunal determined that the disabilities did not have any effect on the claimant's conduct in the occasions in question, the further question of whether any unfavourable treatment was because of that conduct did not arise. Now, it's an interesting case because the tribunal did accept that actually certain consequences did flow from the claimant's disabilities, but it just said, in effect, that link between the reason he lost his job, there was no link between the reason he lost his job. And it did that by looking very carefully at each and every incident the employer relied on for dismissing, and made that conclusion. Now, it's certainly an interesting judgment, one that I would urge you all to read. What we can learn from this is as follows. Despite medical evidence suggesting disability might give rise to certain conduct, respondents are still left in the position of being able to argue on the facts that behaviour doesn't in fact arise in consequence of disability. And of course, for that, you need to have a very careful analysis of the medical evidence, and 2, a careful analysis of the facts of the relevant events. In terms of claimant lawyers or those representing claimants, what you shouldn't assume this case tells us is that the evidence of a general nature, medical evidence of a general nature, will always be sufficient to prove your case in relation to the specific facts. And we can imagine that what this case might urge those representing claimants to do, or indeed respondents, is to put very specific factual questions about the incidents to medical experts, which indeed you may well done in other cases, it wouldn't be unusual. But effectively, it's not resting on our laurels thinking, well, the medical report, more generic medical evidence is enough. You may need specifically your psychiatrist, your psychologist, to answer questions on the specific incidents, and whether they take the view that those reactions from those individuals are linked in some way to their neurodivergent condition. Okay, that is the end of my slot. I'm going to pass back to Robert. Just noting the time, it's 18 minutes past, Robert.
Yes, thank you, Claire. Okay, we've covered the legal aspects. How can employers do better? What lessons can be learned from those cases? I'll refer back to them as we go through these final slides. But essentially, we're looking at this from a practical perspective to finish. We're asking what can be learned from the community, from judges, as we've hinted back to, using resources that are available to the tribunal and the standards that the tribunal will apply to itself, and taking some of those standards and applying them in an employment context. It's not saying that we're anticipating, and certainly the tribunal wouldn't anticipate, that every employer behaves exactly like a judge. But to take a leaf out of the judge's book, as it were, is a very helpful way of thinking about how employers can improve their accommodation of neurodiversity in the workplace. Performance management is always a difficult aspect, and Claire touched upon the reasonable adjustments element of that in the case of McQueen. We've noted down two observations from the case law. Policies and guidance is obviously important. NPower have hopefully learnt their lesson back from 2018, that failing to implement policies and set out those policies, the terms clearly, is going to expose an employer to an awful lot more risk when an issue arises in the tribunal. So setting out those policies from the start is vital. But then it's not only about having those policies, it's about following them and adapting them. And that requires employers and everyone else, of course, to be able to identify the behaviours which may be attributable to neurodivergent conditions. And this, again, is really difficult. There is no set trait to any one condition. They can arise in very different ways. And Claire touched upon a really important point from the case of Morgan, which is about masking. And so in various different conditions, there can be ways that people will try and overcome that, will try and hide it. And being able to identify masking is in and of itself a crucial element, albeit is challenging to do so. But becoming more familiar with the traits and increasing knowledge and awareness of the conditions is going to be the best place to start, and learning as we go. And then specifically about disciplinary and grievance processes and the hearings that can occur therein, we would suggest that it's helpful to have the tribunal's expectations in mind. Of course, it's always good to think about how a tribunal would interpret the situations that an employer is taking their employee through. But what does it mean practically in this context? Well, if we go back to the Equal Treatment Bench Book, there's some very helpful guidance, as I touched upon earlier, with mental disability. And we've set out some of the standards that are in that chapter. So there is suggestions on how to make appropriate adjustments in the tribunal for people with neurodiverse conditions. And of course, those same adjustments would apply in a disciplinary and grievance hearing. Communication skills, which is vital, and we touched upon that with respect to autism at the start, is fundamental. And there are some suggestions, again, in the bench book about how to best communicate and ask questions. The issue of raising disability is one I'd like to look at, because this is, again, it poses a lot of challenges for employers, because raising a disability is not advisable, certainly not in a forthright way. But Mind have suggested, and this has been repeated in the bench book, Mind have suggested 3 potential ways about asking about mental distress in this context. So, for example, you appear to be distressed by this situation. Is there anything which would help reduce your anxiety? Or another way, I'd like to ask you if you're experiencing any mental distress or have a mental health condition. If you want to tell me, say yes. But if you feel unable to do so, then say no comment. So there's some suggestions there from Mind as to how they deal with that. And again, that's suggestions that the tribunal will apply, but equally are applicable in the context of a grievance hearing or in an employment context generally. And then finally, they're adapting to remote working, because as we're doing today, a lot of this is still done remotely after COVID. And that is becoming, in many ways, a new element of normal within employment contexts. And remote working can present its own challenges with respect to neurodiversity. So some of the suggestions within the bench book are using visual aids in a remote context, taking things more slowly than perhaps you otherwise would. And also simple things like ensuring that when people's faces appear on a screen, they're not darting about, because with various conditions that can pose a problem. So ensuring that people are fixed on their place in the screen is just a helpful, practical way to ensure that that grievance hearing goes as best it can from the perspective of the employer. And then also the Advocates Gateway, another very helpful resource which counsel, barristers, solicitors use in hearings. And it has various toolkits with suggestions about how to deal with ethical issues, vulnerable individuals, and asking questions of them in court. Again, an appropriate way of asking questions in court or tribunal is equally an appropriate style to adopt in a grievance hearing with respect to making those adjustments for vulnerable individuals. So if we're looking at neurodivergent conditions, there is practical toolkits available. Toolkit 3, for example, on autism, suggests that when you're asking questions for a person with autism, you would ensure particularly effective planning so that there's no unnecessary disruption that occurs. Again, you would use visual aids and make use of those perhaps more than in other situations. And importantly, not to try and stop or suppress the behaviours that arise, but to take those as part of the questioning and accommodate them. So again, some practical tips that can arise in lawyers' practice, which could equally apply in the context of the workplace and those hearings. But it's really important to remember in all of this, and we've been looking at it from an employment law perspective. So we've been talking about the challenges that can be posed by neurodiversity. But it's not just challenges. There are so many benefits that come from having a neurodivergent workforce. And just in the preparation for this talk, I found an article from back in 2017, but I think the words are still applicable, from the Harvard Business Review. And they were looking at neurodiversity as a competitive advantage. And they said, the article finishes with this, that work for managers in accommodating and adapting to the needs of neurodiversity will become harder, but the payoff for companies will be considerable. Access to more of their employees' talents, along with diverse perspectives that may help them compete more effectively. Innovation, they note, is most likely to come from parts of us that we don't all share. So that goes back to the point that Claire made about celebrities who've raised their own experiences with neurodiversity. People who've made great success and great strides in the world often do so because of, not in spite of, their neurodiversity. And I think the finishing point is that it's employers who are best able to accommodate neurodiversity within their workspace. They will be the employers who benefit most from that talent and innovation that it can provide. So that's a finishing point for us. We've then put the links to some of those guides that I've made reference to previously. So the ACAS Guide to Neurodiversity in the Workplace is a very helpful place to look for more information. Again, the Equal Treatment Bench Book, many of those, not all of them, but many of the suggestions there apply or could apply in a workplace, particularly in hearings for grievance and disciplinary policy. And the Advocates Gateway Toolkit's not just applicable in this context of neurodiversity, but very useful for other contexts too. And then a final shout out, because fellow Park Lane Plowden employment members Andrew Sugarman and Amy Rumble have recorded relatively recently a great podcast on the issues around expert evidence in disability-related employment claims. And they do touch upon neurodiversity. It's the expert, Dr. Colwell, who Claire referred to earlier, refers to neurodiversity at around 18 minutes in. So the link for that podcast is there. And we'd encourage you, not just for neurodiversity, but for expert evidence in general, to give that podcast a listen. And with that, we go to any questions. Thank you.
Thanks very much, Robert. I thought that was a really great way to end the talk, talking about sort of getting away from the law, if you like, and thinking about the greater picture in respect of neurodiversity and the fantastic things that those with neurodiversity can bring to the workplace and should be celebrated. So that's a really positive ending. And I hope you found it interesting. Certainly Robert and I have in our research and consideration. And we welcome questions. We haven't got time for lots of questions in the chat box, but our email addresses are there. We will be sending out the slides to everybody who's attended, and please get in touch if you've got any more queries. But that's the end of our webinar. Enjoy the rest of your lunch.